Well, good evening, ladies and gentlemen. Good evening. My name is David Shepherd. I'm Pro-Vice Chancellor and Dean of the Faculty of Humanities and Social Sciences, and it's my very great pleasure to welcome you all this evening to this lecture, a lecture which is hosted by Keele University School of Law and also by the International Law Association British branch. And it's very important that we note that this lecture has been organised to celebrate the launch of Keele's new degree, Master of Laws, LLM in International Law. And I'm certainly, as Dean of the Faculty, which hosts the law school, extremely proud and excited about that development. I'm also very pleased to be able to introduce our distinguished speaker this evening, Judge Howard Morrison, who since March 2012 has been a judge at the International Criminal Court. He was elected for a term of 9 years last year. He is assigned to the trial division of the ICC. This is the culmination of a long and very distinguished career in the law. Judge Morrison was called to the Bar of England and Wales by Gray's Inn in 1977 after graduating in law and working in development in West and then East and Central Africa. He practiced in criminal, civil and family law until 1986, when he was actually appointed resident magistrate in Fiji, being promoted to chief magistrate at the time of the 1988 military coups. He was called to the Fijian bar and then served as a sort of ad hoc attorney general in the Caribbean in 1989. He was called to the bar of the Eastern Caribbean Supreme Court. In 1989, he was appointed OBE for his services to the Fijian judiciary during the military coups. He returned to the UK and practiced here on the Oxford and Midland circuit in criminal law, both defending and prosecuting. He was appointed Recorder of the Crown and the county courts with authority to sit in criminal, civil and family law jurisdictions. In later years, he defended at both The Hague and in Arusha. In 2001, Howard was appointed Queen's Counsel and a circuit judge in 2004. He teaches international criminal and human rights law and has done so in a number of countries. In 2007, he was appointed CBE for services to international law. In 2009, he was appointed as a judge of the Special Tribunal for the Lebanon, but was transferred to the ICTY the same year following the resignation of the then UK judge. So an enormously rich and distinguished career. I think we're very fortunate to have somebody of Howard's stature to help us to celebrate the launch of our LLM in international law. And I'm sure, like you, I'm very much looking forward to hearing what he has to say about international law, hopes and fears. So please join me in welcoming our very distinguished speaker. Thank you.
Thank you. I think that's it. Well, good evening and thank you. Let me start off immediately by saying how important it is to progress legal education from the bachelor stage to the master stage and then onwards. When I was called to the bar in 1977, neither I nor any of my contemporaries, immediate contemporaries, went on to do a master's degree at that stage because you didn't have to. And if you're going into practice in particular, it probably wasn't necessary, interesting though it might have been. But the bar has changed and has raised. And now, in order to achieve what you might have been able to achieve with a bachelor's degree even 20 years ago, it's a master's degree. And as I've said to people, maybe in 10, 15 years' time, the bar will go up and it'll be PhDs. But make no mistake, certainly to work in international law and certainly to work through the United Nations, a master's degree has become a necessity. So for those of you who are doing it, congratulations. For those of you who are thinking of doing it, I would do it. I know it's expensive, I know it's time-consuming, but time and money spent on education when you're young really is never wasted. And so let me endorse that straight away. I'm grateful for a recent development in psychology in California, which I read. I'm told that 10% of you will remember what I say for 48 hours. 20% will remember what I say for about 24 hours. The remaining 70% of any human audience simply sits there immersed in their own erotic thoughts. Now, if true, it's a great comfort, because it means that whatever I say, the majority of you are going to be enjoying yourselves. I start off with the usual and probably fruitless disclaimer that what I say is my personal view. It's not policy for the ICTY, where I still am until I finish the trial of Radovan Karadzic and move over to the ICC. But this isn't policy. These are the meanderings of the mind of someone who's been involved in the law since I was a law student, starting way back in 1969, and doing various things ever since. And someone who's been immersed in international criminal and humanitarian law since I started defending at the Yugoslav Tribunal in 1997. But for those of you who are not familiar with it, the concept of international law, laws of war, things of that nature is not a new concept. Rules were developed in China some 3,000 years ago for the conduct of war. In Europe in the Middle Ages. And it's been a slow progress ever since. It was a question of fighting a just war. The idea of taking prisoners and not executing them was something that developed. I don't know how many of you remember that part in Henry V, where he says after the Battle of Agincourt, execute the prisoners. Well, he'd be committing a war crime now. But it was commonplace in those days, so things can only be said to get better. In more recent times, there was a failed attempt to hold the Kaiser culpable after World War I. He had actually fled to Holland, and the Dutch refused to extradite him, so that came to nothing. The League of Nations was a bit of a false start. But it wasn't really until the end of the Second World War, when Nuremberg and the Tokyo tribunals were set up, that the idea of pursuing people for crimes against humanity and for war crimes really gained momentum. But remember, it wasn't an instant thought. Stalin's idea was to, at the Yalta Conference, was apparently to take 50,000 Germans at the end of the war and summarily execute them. Churchill apparently was of the view that the leaders of the Nazi regime should be identified and then summarily shot. And it was not until some lawyers, in fact American lawyers, persuaded, legend has it, persuaded everyone that the good idea was to set up a court and try people. Now, Nuremberg and Tokyo, as I've said before, suffers from three criticisms. The first of all is the old one of victor's justice. The second is that there wasn't a really proper independent appellate procedure at the end of the trials, which was particularly important for the third reason, and that's because of the death penalty. You can release somebody who's been wrongly imprisoned. You can't do much about somebody who's dangled and died at the end of a rope. So it was a cogent criticism that the Tokyo tribunals were even more widely criticized for their process. In fact, an Indian judge resigned in disgust from the Tokyo tribunal, saying that he wasn't going to participate in what he described as a kangaroo court. So it was an important beginning, but it wasn't without its flaws. Geneva Conventions came into play in the late 1940s in the Genocide Convention, but then really the idea of an international court or international courts fell into dormancy until the war in the Balkans in '93 and the genocide in Rwanda in '94. One might say that the ad hoc tribunals for Yugoslavia and for Rwanda found their genesis in the failures of the United Nations to prevent or properly deal either with what happened at Srebrenica or happened in Rwanda as a whole. Whether or not one subscribes to that argument, the net result was that those tribunals were set up. But it wasn't an easy progress. The late Professor Nino Cassese, as one of the fathers of international law, was appointed the first president of the Yugoslav tribunal. And there was a very real danger that it was going to effectively die a death before it even started. But because of his incredible enthusiasm and hard work, it got going. And the Yugoslav tribunal has now dealt with every one of the 161 indictments that it set out to pursue. The Rwanda tribunal has done most of them. The only ones that it hasn't been able to deal with are those people who have fled the jurisdiction or may be dead and certainly can't be found. But it certainly dealt with all the other cases. And so there has been a body of case law developed, adding to customary international law, and an impetus to take it further. And the impetus to take it further resulted in the negotiations for the Rome Statute and eventually the establishment of the International Criminal Court in 2003. So it's a court which is still in short trousers. It's 11 years old. It's got a way to go. People who criticize it for not having done more, perfectly valid criticisms in many ways, but let's face it, legal systems don't develop to maturity and do everything they're supposed to do in 11 years. And I hold up the UK as an example. We've had a criminal justice system for something like 800 years, still under criticism, still developing. People still criticize it and think it doesn't do everything it should do. Well, that's the nature of human beings. It's the nature of institutions. But the ICC is a thing that in the 1980s no one would have believed it was ever going to be set up. In the 1990s there were hopes but not real expectations. And when it was set up, a lot of people stood back and said, good grief, it's actually happened. We've actually got 60 countries signed up. And so the ICC came into existence. Basically, the court, the ICC itself, I'm afraid, there was a sense of euphoria that here was a court that was going to solve all the world's serious legal problems. And expectations were great, and I think they were too great. And the reality has set in slowly. The honeymoon period is over. We're now into the early days of the marriage. As with all honeymoons and marriages, things don't always run as smoothly as you expect them to do. Problems arise, they have to be resolved, and they have to be resolved by compromise if you don't want the marriage to end in some form of divorce. And that's exactly the process which the ICC is going through at the moment. It's not, as people think, some people think, a United Nations court. The ICC is governed by the Assembly of State Parties. The Assembly of State Parties are the groups, are the people, the countries which have signed up to it, in effect. They are the governing body. They are the people who supply the money, the budget. The court has 18 judges, of whom I'm one. I won't go to it full time until I finish Caradich, which will be probably March, April next year. But when you think about it, here is a court with 18 judges. You go to Birmingham Crown Court, where I used to sit, and on any one day there were 20 judges in that one court building alone. The UK has something like 1,000 judges to deal with the cases which are generated by one country. So it's inevitable that the ICC can only deal with a very small number of cases, and the most egregious cases at that. That it was set up to do. It was also set up to be, in a sense, a ginger group, to really create two ideas in the world population. First of all, an end to immunity and impunity for people who think they can get away with anything. And secondly, to encourage countries to deal, as and where possible, with their own allegations of war crimes and crimes against humanity. And that's emphasized by the provision in the Rome Statute of complementarity. And what complementarity says, in effect, is this: is if a country is able and willing to prosecute its own alleged criminals, then the ICC has no mandate and no jurisdiction. So it's not a court of first resort by any means. It's very much a court of last resort. I always tell people this as well. The ICC is not a human rights institute. It has human rights at the basis of international humanitarian law, but people who expect the court to act as a human rights institute are going to be, I think, disappointed. It's not a PhD factory, although many of the people who work and live there do PhDs and are encouraged to do so. It goes back to what I said before: bachelor's degree, master's degree, PhD. And so many of our bright young things who help us out at the court are very recent PhD holders, and very valuable their work is too. We deal with the most serious crimes in the world. Genocide, which is a crime against humanity, but is so egregious that it has a standalone status in its own convention. Other crimes against humanity, and war crimes. And I think, and I said it to some students this afternoon, some of whom are here, they'll have to bear with me saying it again. I think the way forward for us all is to start to view some of the environmental crimes that we see as crimes against humanity, some of the transnational corporate crimes that we see being effected as crimes against humanity, and coming up with the crime is going to be the crime of aggression, which is going to be the subject of another conference in Uganda in 2017, after which I think there's a very real chance that it'll be on the Rome Statute and therefore on the statute book of the ICC. The crime of aggression is one that frightens people off the most because it's a very broad criminal concept to have a crime against aggression. The other crimes which I think are going to be come more into public play are piracy and terrorism in various forms. One has to be very careful about what one designates as terrorism. The old adage is too that one man's terrorist is another man's freedom fighter, and you have to be very cautious about blanket allegations of terrorism. It's a bit like an elephant, you know it when you see it. Piracy is another matter, and one of the courts that's in The Hague at the moment, the Special Tribunal for Lebanon, which is dealing with the assassination of President Hariri in the Lebanon. It was always Antonio Cassesi's dream that when it finished doing that, it would be turned into a world's terrorism/piracy court. And there's a body of jurists in Geneva in particular, I know, who are keen on making that a reality. And a good thing if it was. There's an advantage in having a terrorist court removed from your domestic situation for security purposes. You put all the trouble into somebody else's pocket. But in the 1980s, the ICC seemed an impossible dream. Nobody expected it to get the 60 votes. And bearing in mind the current difficulties in the relationship between the ICC and the African Union, one thing that was apparent, and I was in the PrepComs in New York in the early 2000s, is that nobody expected a large number of African states to join at an early stage. And to everybody's surprise, 34 African states very soon joined, along with a number of other states. Those 34 states were more than 50% of the required 60 to get the court going. So you can see it was a very significant event. Virtually all South American countries are members, and you can look on a map to see which countries are not. Unfortunately, the countries which are not still remain some of the world's big players. The United States, which under a previous administration was not keen on the court, but under the current administration is certainly not hostile. Russia, China, and India. When you add up the populations of those countries, you can see a vast swathe of the world's population is not signed up. They are still technically within the jurisdiction of the court, however, because the court has jurisdiction by a number of mechanisms. One is self-referral, and half of the cases at the ICC are self-referrals. All the cases, of course, one of the complaints by the African Union is the perception that it's an anti-African court because all the current situations derive from the continent of Africa. But half of those were self-referrals, 2 were referrals by the Security Council. So the Security Council can, in theory, refer a situation in any country to the ICC, whether that country is a member of the Assembly of States Parties or not. And Libya is a prime example of that. Libya is particularly important because although there are difficulties in the case of Saif Mohammed, which is currently sub judice, recently the ICC determined that another defendant could be tried under the complementarity provisions in Libya. So complementarity is real, it's not imagined. It's a very real part of the court's mandate. There are now 122 countries. Standing, or rather sitting in the wings, is Indonesia. Now, if Indonesia joins the ICC, it's going to be very interesting because it's the most populous Muslim country in the world. And one of the things that international law is going to have to do is to recognize the importance of Sharia law in all its forms and the way that Muslim countries interact with a more Western approach to law, which is the law that's currently applied. I think that's going to be a fascinating delve into the way that jurisprudence can homogenize. Those of you who are thinking of a master's degree thesis or a PhD thesis, I would have thought that was one of extreme importance. What is the correlation going to be between Sharia law and the international aspects of Sharia law and international law, customary international law as we know it? I don't have an answer to that. I'm hoping somebody does, because it's going to be a very interesting amalgam if and when it happens. The whole basis of the ICC is the concept of no immunity and no impunity. So it doesn't matter who you are. If you are accused of committing egregious crimes against your population or the population of a neighboring country or any other state, then you stand liable and there is no functional immunity to stop you being indicted. That's pretty tough, but it actually is what founded the concept of both Nuremberg and Tokyo. So this is not an idea which has sprung out of the woodwork. This is a concept which has been with us for some 70 or 80 years. But the ICC is not a panacea, and it suffers from three things which make life very difficult for it. The first place, it has no police force. The ICC depends entirely upon state cooperation. It can reasonably expect cooperation from the members of the Assembly of State Parties, who are, after all, its governors and founders. But it also hopes for cooperation from other states as well. And that's something which is very important. The second thing is that it simply isn't big enough to deal with all the situations in the world. It has to look very carefully at what it can effectively afford, which is the third problem. It's the age-old problem, it's money. You get what you pay for. The court is expensive by any standards, but you have to compare it with other ways of dealing with the world's problems. And when I tell you that the annual budget for the ICC is roughly the same as the cost of 2 advanced fighter jets, it begins to put it into perspective. And if the object of international criminal law is to persuade the international community that war and aggression is something which isn't the first choice in a conflicting situation, but comes to be the last choice, then one has to make a value judgment as how much money you are going to spend on that system in order to allow it to work. It's not a plea for money, it's a reality. That's the way it is. We take the rule of law for granted. We take the domestic rule of law for granted. It's a little less easy to take the international rule of law for granted unless there is an end to impunity and immunity. But when the rule of law breaks down, it does so very quickly and very suddenly. I'm not talking about failed states either. Remember the floods in New Orleans? And the rule of law broke down in New Orleans within a matter of hours. Indeed, there were members of the police force who were afterwards charged with crimes that were committed during that breakdown. So it doesn't matter what society you're talking about, whether it's a remote state in Asia or Africa or South America or Western Europe or America, once the rule of law has gone, we are all at risk. And if you extrapolate that from the national and domestic situation into the international situation, then you see the value of international law. And the world is getting, it's often said, but I think it's true, the world is getting a smaller place because we now know what's happening around the world in an instant. You turn on your mobile phone, you turn on your iPad, you turn on your computer, and you can see pictures of what's going on 10,000 miles away almost instantly. For your generation, the younger people, this is nothing strange or nothing new. But Just imagine a world where there was no computers, there was no internet, there was no iPhones, that you relied upon landline telephones or the mail or television cameras if you were lucky. You don't actually have to go back very far for that. And I remember my first mobile phone. It was the size of a brick. And you walked around very self-consciously talking into your brick. But you couldn't talk to many people because hardly anybody had one. And they were, I think, £1,200. This is back in late 1970s. Well, that's like paying £3,000–4,000 for a mobile phone now. So the world has changed, and it's changed instantly. It is said that the vote in the British Parliament on military action in Syria was affected by tweeting to MPs. I don't know if that's true, but if it is, just consider what a force instant communication can be to change what may be quite radical political and military moves, if that's the case. But I'm told that it is. But I think there are another thing that's going to make international law even more important, and this, especially for the younger people, might be a little bit pessimistic. So if you're of a delicate nature, now's the time to go into erotic thought mode. It's going to get worse. Why is it going to get worse? Well, because the world's population is increasing exponentially, getting bigger and bigger and bigger. And the world, surprisingly, ain't getting bigger and bigger and bigger. So more people on the same size planet. The corollary of that is that resources are going to get scarcer and scarcer. We have already had, for all of recorded history, territorial wars. We've had religious wars, we've had ideological wars. Those, I'm afraid, are in one form or another going to continue. It's probable that we've had an oil war. It is very likely that there will be other oil wars, but I think there will also be mineral wars. Look at the situation in the Democratic Republic of the Congo. I think there will be food wars. I think there will even be water wars with an ever-increasing population and diminishing resources. There will also be territorial wars which are not based upon simple greedy gain for territory, but the need for populations to expand into neighboring territories because there simply isn't going to be room in the home territory for them. Now, all of these things are going to have to be regulated, and those things, by their nature, cannot be regulated by domestic law. Because once the boundary has gone and the aggression has started, it is only international law which is going to contain it. And unless we have a working system of international law to deter, and deterrence is probably the main part of it, then things could look pretty bleak. So I don't want to be pessimistic, but I think that's the realistic prognosis for the future. When we're still 99% dependent on oil, and oil is going to run out in the not too distant future. And if oil doesn't run out and we find huge reserves of it in the Arctic or the Antarctic, are we going to exploit that? Are we going to melt the ice caps? Is there going to be environmental damage? One thing is irretrievably linked to the next. But the one thing which irretrievably is also linked to the solution to this is to have sustainable treaties and a sanction at the international level. So for those of you who haven't decided where you want to go in the law, let me persuade you that international law and the various facets of it is quite a good bet. Criminal law in England is pretty tough at the moment, I know. Getting training contracts for a solicitor, getting going at the criminal bar. And if you have a working niche that you're interested in, then let me advocate international law. There aren't that many jobs, I put that in, and the jobs that there are going to be at the ICC or some at the ad hoc tribunals, some with the United Nations, and some with government agencies. But these are fields which, I mean, none of you are here simply for the love of academia. Everybody wants a job at the end of it. It's a very valid and realistic option to think, what am I going to do with my expensive degree or degrees? And so do take a look at the websites for the ICC, do take a look at the websites for the UN and other sources of international jobs. We haven't yet, I don't think, as a society, as a world society, and I said this earlier today, but it bears repeating, we haven't yet grasped that we're all in the same boat. There are still plenty of people, and certainly plenty of politicians, who think that if the boat sinks, their first-class cabin will remain afloat. Well, it ain't. We're all in the Titanic. If it goes, and it sinks below the surface. We only have ourselves to protect ourselves. We only have the institutions that we create to protect ourselves. And when we've created them and that they are capable of doing good, then we need to sustain them, and we need to look at them critically, but we need to look at them positively. There is nothing wrong with constructive criticism. There's nothing wrong with emotional criticism. But at the end of the day, international law is about what we are all going to be involved with, and that our children are all going to be involved with, and our grandchildren are all going to be involved with. Room for narrow nationalism, I'm afraid, is increasingly scarce. One of the things that worries me, one of the fears I have, is that human beings by their nature tend to retreat sometimes into dark corners when they see something, a light shining that they don't particularly want. And a retreat into narrow nationalism and national interests, I think, is a huge mistake. And I think one that most of us here would recognize is not the way forward. Nothing wrong with independence, nothing wrong with sovereignty, both very important concepts. But an escape into narrow nationalism leads to prejudice, leads to discrimination, and at the end of the day, it's antithetical to the idea of the rule of law and certainly the rule of international law. That may sound a bit like preaching, and I suppose it is. And I don't mean it to sound like that, but it's something I do feel very personally and passionately about. I went into international criminal law almost by chance. I answered an advert in Council magazine in 1997, and it simply said something like, would you like to defend at the ICTY? Oh, yes, I thought. Filled in the form, sent it off, and then I thought, what's the ICTY? So I looked it up, and the Yugoslav tribunal, of course. Having sent my form off, I heard nothing. I then got a phone call in very bad German, even worse than mine, I'm pleased to say, about 3 months later, and it was a Croatian who was in the detention center in The Hague who wanted representing. So off I went to The Hague to represent him. That case led to 2 others, and those led to a case at the Rwanda tribunal representing a former Rwandan cabinet minister charged with genocide. I was bitten. And once you're bitten by the international law bug, I'm afraid there's no ready antidote to it. You've just got to keep working at it. So I warn you all, if you get into it, it's sometimes very difficult to get out of it. I'm not going to get out of it, if I get out of it at all, until I'm 71. So there you are. It's almost 30 years away, so I shouldn't worry about that too much. But I've come to the view, since being involved as a defense counsel and then as a judge. I was a judge briefly at the Special Tribunal for Lebanon. All I managed to do was to help write the rules of evidence and procedure with Nino Cassese and a very brilliant Dutch jurist called Bert Schwartz. The 3 of us sat down, and we were locked into a dismal hotel in the suburbs of Amsterdam, and we weren't let out until we finished it. And it really did happen like that. What worries me slightly is that both Nino and Bert have since died, so I'm wondering now. I take the daily aspirin. I didn't last long there because Lord Bonamy resigned from the Yugoslav tribunal just as the Karadzic case was starting, and that was too good an offer to refuse, to change those horses. And then when the ICC came up, then I determined to have a go for that, because I'd been a huge supporter and proponent of it ever since the idea was first mooted, and I've been incredibly lucky. It's an enjoyable field of work, but it's not an easy one. Just as judges, criminal judges the world over, I spend my days listening to tales of horror and terror and the most ghastly crimes. I visit mass graves. I do things that you'd really rather not do, to be absolutely honest, but it's part of the setup, it's part of what you have to do, and you don't get any counselling. If I was a social worker in Birmingham, I'm sure I would do. And I'm sure their life is harder than mine in many ways. But don't think it's an easy road, that's what I'm saying. It's not. You're dealing with hugely emotional, hugely difficult, hugely provocative, hugely contentious situations, and you're dealing with them sometimes in conditions of great stress. But that's what it's about. It's got to be done, and it's got to be done as well as possible. There's no shortcut. International criminal law and the international criminal courts and tribunals are not there to convict people. They're there to try people. And so it's very important that standards of due process and the standards of evidence collation and the examination of evidence and the judgments are set to the highest standards, and there's no room for complacency. There's no room for political pressure. You would be a fool to say that international law was separate from politics. Of course it isn't. It's co-joined with politics at virtually every turn. But two places where politics must not enter. First is into the courtroom, and secondly is into the judgments. And if you haven't got people and judges who can make that distinction, then frankly, they shouldn't be doing the job. They should go elsewhere. There was something that I was thinking of going about. There are many aspects of international criminal justice in the ICC I simply haven't got time to talk about. It may come out in questions, and therefore I'll leave it to that. There's the questions of victims and reconciliation, the questions of the delays, the questions of the costs, the substantive issues of law, which won't mean much to some of you, but the great debate about different standards of aiding and abetting, and the dilemma between modes of liability, joint criminal enterprise, and the German theories of controls of the crime under the German jurist Roxin. Has anybody read the German jurist Roxin and understood him? Oh, good. I thought it was just me. Well, that's encouraging. But I leave you with these thoughts. The ICC is a treaty court. The exercise of its prerogatives can only come from the terms of the treaty, the Rome Statute. It doesn't have much room for manoeuvre outside that, and people who expect it to have, I'm afraid, have not really examined its genesis and where it sits. States join the ICC on the understanding that it is only going to be resorted to as a last resort. That's why they joined. And that's perfectly fair and reasonable, and specifically to fight against immunity and impunity. ICC and people who are behind the ICC recognize the importance of local trials and, where possible, truth and reconciliation commissions. I say the ICC is not there to even attempt to replace those. The concept of complementarity makes that perfectly plain. Local trials, in my view, maximize deterrence, and they give a feeling of ownership to the local population, which is why you're never going to do away with national courts. They're so a vital part of the human structure. The ICC isn't there to deprive a competent state of its right to try its own citizens if it can do so honestly and fairly. Of course it isn't. And it's not designed simply to remedy the world's legal problems. No one institution possibly could. As I say, it relies upon state cooperation and the realization that we are all in that same Titanic, and let's try and avoid the iceberg. But as I said before, it's got to be at the vanguard of fair trial processes, and if it isn't, it's not working. We hope that the large countries who are not member states will join. Not going to be in my lifetime, but it may be in yours, or yours, even yours. And I hope so. The United States has got a lot less hostile. Russia has shown very interesting signs by pleading the case for an international legal solution to the Syrian problems rather than military intervention. However cynical one might be and say, well, there's a subtext to that, and maybe there is. but the point is that the international law has been invoked. China, who has a policy of non-interventionist around the world, joined together with the rest of the Security Council in the referrals of Libya to the ICC. So I think there is a slow but steady movement towards it. The last thing is this. I don't believe there is any such thing as foreign policy. I think all countries have domestic policies, and the way they interact with other countries is part of that domestic policy. You can call it foreign policy, but the bottom line is that it's domestic policy writ foreign. And the important thing is that that domestic policy realizes and encompasses that international law and the ICC is here to stay. And we need, as a collective body of intellectuals, to support it. I'd be very happy to answer any questions that I can. I cannot answer any questions about, of course, cases which are sub judice. Thank you very much.